If you were just in a car accident, the very first phone call you get won't be from your doctor. It'll be from the other driver's insurance company. They'll sound friendly. They'll sound helpful. They'll say they just need your side of the story. But here's the truth. That call can cost you thousands of dollars long before you ever see a courtroom. Hi, my name is Brandon Osterbond, and I'm a personal injury lawyer here in Virginia. And today, I want to answer one of the biggest questions that people ask me after a car crash. Should you talk to the insurance adjuster? Let's walk through what Virginia law actually says, what the adjuster's real goal is, and what you should do instead. Insurance adjusters call fast, sometimes the same day, because they want your statement before you understand the full extent of your injuries. You might still be in shock. You might not be in pain yet. You might not remember every detail, and they know that. If they can get you to say things like, I'm doing okay, or maybe I didn't see them, or I'm not sure if I'm hurt yet, they will absolutely use those words to minimize your claim. Now let's talk about the law. Virginia actually has a statute that deals directly with statements you give to insurance companies. It's Virginia Code Section 8.01-404. And this code section allows for a lawyer in court to use a prior statement that you make to contradict your version of events. But there is a limitation in the statute, and it says this. This section is subject to the qualification that in an action to recover for a personal injury, no ex parte affidavit or statement in writing other than a deposition after due notice of a witness, and no extrajudicial recording made at any time other than simultaneously with the wrongful act or negligence at issue of the voice of such witness or reproduction or transcript thereof as to the facts or circumstances attending the wrongful act or neglect complained of. Here's the most important part. Shall be used to contradict him as a witness in the case. Essentially, what that says is that written or recorded statements given to a liability insurance company cannot be used to contradict you in court unless you were allowed to review and correct those statements. That sounds pretty protective, right? But here's the trick. Insurance adjusters never ask for written statements. They ask for recorded statements. And recorded statements aren't reviewable, they aren't correctable, and they usually aren't admissible in court anyway. So you might think, if they can't use it in court, what's the harm? Here's the harm. They use it in negotiations where almost every case is resolved. And the Virginia Supreme Court explained this very clearly in a case called Rulin versus Saman. In that case, an injured man gave a recorded statement to the adjuster on the same day of the accident. That statement downplayed his injuries. At trial, the defense tried to use that transcript to impeach him or to say that he was lying. The Supreme Court said you can't use the statement or the transcript in court to contradict the witness, but you can use, a lawyer can still question you about what you said on that phone call. And the insurance company can absolutely use your statements behind the scene to attack your credibility and reduce the value of your claim. So just because the recording can't be played at trial does not mean it can't hurt your case. It can, and it does. So what should you do when the adjuster calls? It's simple. Say this: I'm not comfortable giving a statement. I am seeking legal advice. That's it. You don't owe them anything. You don't have to explain. You don't have to justify, and you definitely don't have to answer their questions. Now, your own insurance company is different. You may have contractual obligations to cooperate with their investigation, but the at-fault driver's insurance company, you have no obligation to talk to them. If you're not sure which company is which, call us. Sometimes these companies are the same. We help people navigate this every single day. And here's why staying silent protects you. Early in your case, you don't know the full extent of your injuries. Pain may get worse. You may need more treatment. You may not realize what actually hurts. Insurance companies want your statement before you know any of that, because once your words are recorded, they'll use them to justify the lowest settlement possible. Silence is not rude. Silence is protection. If you've been injured in a car crash in Virginia, don't fight the insurance company alone. My team and I handle adjusters every single day. We know what they look for. We know how to protect your case from the very first phone call. You focus on healing, and we'll take care of the rest. Before you go, there's one more thing that you're probably asking. Who pays for my medical bills when I'm getting all of this treatment? I have a full video that breaks that down step by step. Go watch Who Pays for My Medical Care After a Virginia Car Accident, and I will see you there.